You're watching The Legal Breakdown. So, Glenn, this is a question that's been wearing on me, and so I thought it would be best to do an episode about this specifically. Now, we all know that Fani Willis is likely to indict Trump for pressuring Georgia Secretary of State Brad Raffensperger to find 11,780 non-existent votes. Can Jack Smith also bring charges forward in the federal case against Trump, that January 6th case, or does he have to relinquish that entire event to Fani Willis in Fulton County?
Yeah, great question. So often when somebody commits a crime, it can violate both state law and federal law. And I'm pleased to report Donald Trump has done precisely that. With that corrupt ask, right? Just find me 11,780 votes and corruptly declare me the winner. He not only violated Georgia state law for soliciting election fraud, but he also violated any number of federal laws. And in preparation for this discussion, Brian, I printed one of those federal laws out. I'm going to streamline it a little bit because often these statutes are complicated and confusing. So for anybody scoring at home, it's Title 52 of the United States Code, Section 20511, subsection 2B. There will be a test at the end of this video. And here's how it reads, streamlined. A person who, in any election for federal office, knowingly and willfully deprives, defrauds, or attempts to deprive or defraud the residents of a state of a fair and impartially conducted election process by false, fictitious, or fraudulent tabulation of ballots commits a 5-year federal felony. That is precisely what Donald Trump did on that corrupt phone call. So he could easily be charged with a criminal violation of that statute and frankly, plenty others, because I think the big ticket crime that we're going to see indicted against Donald Trump and others for this whole scheme to try to corruptly overturn the 2020 presidential election results is going to be a conspiracy to commit crimes against or defraud the United States. I predict that's going to be the umbrella charge, and then a whole lot of more specific federal statutes will be indicted because he violated any number of federal election laws.
Yeah, and I think what's so telling here is that everybody kind of assumes that the Fulton County case is such a home run because we have that audio recording of him pressuring Brad Raffensperger to find those votes. But it is just as much of a home run in the January 6th case, in the federal case, that Jack Smith is going to bring forward. So I think that bodes well for both of those cases that are still that we're still waiting on indictments for. Glenn, if Trump is convicted for that crime in one case, how does that impact the impending case in the other jurisdiction?
So the way it can most directly impact another case is if you are convicted and sentenced, not just convicted pending sentencing, but if you are convicted and sentenced, that becomes a prior conviction. What does that mean? It means that if in a subsequent trial you take the stand and try to testify, the prosecutors can actually impeach you. In other words, they can cross-examine you as follows. Defendant Trump, isn't it true you were convicted in another jurisdiction of the following crimes? Nothing will knock down a witness's credibility more than being impeached with his own or her own prior crimes. So that is the one concrete way it could impact a future trial. Now, do any of us expect Donald Trump to crawl up on the witness stand in any of his trials? Extremely unlikely. Of course, Donald Trump calls the shots, not his attorney, so he may very well want to get up there and tell his side of the story, which would be, manna from heaven for a prosecutor who gets to cross-examine Donald Trump. But that is one potential concrete impact that a prior conviction has. The other is sometimes if you're convicted and you are to be sentenced after you've been convicted of other crimes, they can serve as what we call sentence enhancements. So you can actually be punished more severely if you have prior convictions on your criminal resume.
Glenn, have you seen an instance where someone is found guilty at the federal level but not guilty at the state level, or vice versa?
Yeah, the one thing that comes to mind, the Rodney King trials. Remember, the police officers were acquitted, found not guilty in state court, but then there was a civil rights case brought against them by the federal government, and for virtually the same conduct, they were convicted in federal court. It doesn't happen all that often. And people may say, well, what about double jeopardy? You can't be tried twice for the same thing. Actually, you can be tried twice for the same thing, just not by the same court, not by the same sovereign. So you can be tried in state court for certain conduct. You can also be tried in federal court for that very same conduct if it also violates a federal law.
Glenn, if Trump is indicted around the same time in both state and federal court for pressuring Raffensperger to find these non-existent votes, is there a rule in terms of which jurisdiction has priority?
There's no formal rule, but generally sort of the rule of thumb is whoever has the indictment lodged first against the defendant, first in time, will likely be the one to first try that defendant. But that's not really a rule. It's really a practice. It's an accommodation among jurisdictions. I had plenty of times when I was prosecuting somebody in DC, and that same defendant would have a criminal charge across the river in Virginia or across the district line up in Maryland. What I would do is coordinate with all of the jurisdictions. And as best we could, we would try to come up with one unified approach. Where does it make the most sense to try the defendant first? And I'll tell you, Brian, often it came down to who has the strongest case. Because even when multiple jurisdictions are involved, you really do want to put your best foot forward and take your best shot at holding a criminal accountable, particularly a criminal who has been, committing offenses in multiple jurisdictions. Then we have to add to that the sort of natural inclination that, the feds have the big hammer, and the states often will take a back seat to federal investigations and federal prosecutions. Here's what I hope. I hope all of the involved prosecutors will coordinate, sort of effectively and candidly with one another and try to do what's right, frankly, for the nation when you're dealing with a criminal former president.
Well, you brought up this idea of whichever jurisdiction has the stronger case you would hope goes first. Would we just assume that the DOJ's case would be stronger in this instance because Fulton County would just focus narrowly on the call between Trump and Raffensperger? In theory, the DOJ case would have exactly the same crime, but then all of the other elements of Trump's overturning the election, inciting the insurrection on top of that. So in theory, just on its face, wouldn't it seem that the federal case is stronger against Trump?
Yeah, I think it's a fair point that if you're looking at the charges that arise from that dirty phone call that Donald Trump placed, those charges, those criminal counts, when indictments are returned based on that specific phone call, you would think that the trial in federal court and the trial in Georgia state court will look nearly identical. It'll be the same evidence that's presented, the same recording, the same witnesses. The thing is, there's going to be a lot of meat on the indictment bones, I predict, both in Georgia and in the federal jurisdiction. So it really depends on what the other charges are that are brought against Donald Trump in those two jurisdictions. And without knowing, for example, whether Fani Willis will use Georgia state RICO laws, as she has done in the past, and as we've had some hints that she may do for the crimes surrounding the election, it could end up making the Georgia state case somewhat stronger than the federal case. It really, the devil's in the indictment details. And until we see those two indictments actually issue from the grand juries, we're not really going to know which case might be stronger and which case it would make the most sense to try first.
But what's clear is that the venue in both of these cases would be in Georgia. And so we'll see the state case in Fulton County. And then we would also see, because the crime actually happened in Georgia, it took place in Georgia, then that federal case would also be in Georgia as well, correct?
Well, but you're right, but
or would it be in DC because Trump was in DC when he made the phone call?
You know what? I think there could be an argument that venue could be in either place, but here's the complicating factor. I think all of these crimes, not just the Georgia state crimes, but remember, there were 7 battleground states that had false electors trying to corruptly overturn Joe Biden's win. So I have a feeling that there will be this one overarching conspiracy charged, and that conspiracy will be properly brought in the courts of Washington, D.C., because that was a D.C.-driven conspiracy. I mean, does anybody really believe that in 7 battleground states, all of these Republican, politicians and campaign operatives coincidentally and simultaneously came up with a fake elector scheme. No,
Yeah.
this was a Donald Trump, John Eastman, Rudy Giuliani, and others orchestration. The conspiracy was in DC. So even though the crimes fingered out across the nation, I would expect the case to be brought in DC, not in Georgia or in any other state, even though there were crimes that may have been committed in those other states.
Okay. Glenn, to game this out, let's just traffic for a moment in this dystopian nightmare and temporarily raise everybody's blood pressure who's watching. But let's say that Trump wins in 2024 and he's convicted by both the DOJ and Fulton County for this crime regarding pressuring Brad Raffensperger to find these votes. He would obviously pardon himself as far as the federal case goes, but is there anything he'd be able to do to evade accountability at the state level?
Yeah, a good and scary question, the stuff of nightmares. So first of all, let me start with the federal pardon. I have to believe the Department of Justice would contest in court a self-pardon by a sitting president of the United States. I don't think.
Just real quick on that.
Yeah.
If Trump installs some hardline lackey as attorney general, would that person be able to prevent the rest of the DOJ from fighting that in court?
See, you just found the even more corrupt approach that Donald Trump has probably already thought of, right? One of the reasons we have to believe Donald Trump will try to push his federal trial date well into 2024. He'll probably try to push it until after the election because he'll be betting on winning the election, appointing a yet another corrupt attorney general and ordering him to dismiss the pending case against him. That is a different battle that would have to be fought. In theory, if a special counsel was still in place, Donald Trump wouldn't have the authority, at least not the lawful authority, to terminate the special counsel. So it gets very dicey. But so I think that is a legitimate concern. And that's one of the reasons that federal case needs to go to trial promptly. It needs to be resolved well in advance of the 2024 presidential election. But then going back to the pardon question, if Donald Trump is elected and tries to pardon himself because he already stands convicted, I think the Department of Justice would drag that into court and fight tooth and nail, taking the position that a president cannot commit crimes with impunity and then pardon himself. If he could, he could assassinate all of his political foes, and if he was ever convicted, he could pardon himself for it. None of that makes any sense under sort of our constitutional construct. But then the next question is, okay, well, what about a conviction in Georgia? If he was elected president, what could he do about that? The good news is a presidential pardon power does not extend to state convictions. And there's some more good news. The governor of Georgia doesn't have the lawful authority to pardon people. So it looks like a Georgia state conviction would be pretty much bulletproof against any kind of presidential shenanigans.
Okay, well, is there any way that Trump would be able to appeal any conviction in Georgia, maybe to a higher court that's been stacked with Republican-appointed judges who then could offer him some out?
Yes, just when we were feeling better about things. Yeah, you're exactly right. First of all,
I told you we're trafficking in a dystopian fever dream here, so
yeah,
I made that caveat up front.
Have an extra beer tonight to try to get myself to sleep. So no, here's the thing. Every single criminal conviction of any consequence is appealed. I can just tell you, 30 years as a prosecutor, every conviction I won was appealed. It's just par for the course. In fact, if a defense attorney fails to file an appeal, the first thing the client does is file an ineffective assistance of counsel motion against his or her lawyer for failing to file an appeal. So Donald Trump's team will undoubtedly appeal any conviction anywhere in any court, federal or state. And then it becomes a little bit of the luck of the draw. You have to hope that the judiciary holds strong, that it resolves the appeals sort of lawfully, appropriately, in accordance with the law in the jurisdiction in which the court sits. And then ultimately, does it make its way up to the Supreme Court? It might. There is actually a way for state cases to jump in to the federal system, and he could try to appeal even a state conviction all the way up to the Supreme Court. Here's the one thing that I hold fast to. The Supreme Court has been a parade of horribles on the rights of the American people, but where they have held pretty strong is in the sort of election challenge arena. Why? Because I think they know intuitively they know that if they do anything that allows a Donald Trump to become virtually a dictator, well, dictators have absolutely no use for a Supreme Court. So if they do anything to help install Donald Trump as a dictator, they're going to be cutting off their nose to spite their face. They're going to be threatening their own status as being supreme and above the president of the United States as the last word to decide the legality and constitutionality of things. And so I think the Supreme Court will continue to rule against Donald Trump at every turn. And I hope that's not just sort of naive hope on my part.
All right, well, we'll leave it there. Obviously, some stuff of nightmares in there, but we really appreciate all of the good information that you just shared. So for anybody watching, if you want to stay on top of this legal news as soon as it breaks, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.